All right, welcome everyone to week four of our international law journey. We're quickly going through the substantive aspects of the course. We're already a third through everything, which is pretty crazy to say. It's gone very quickly so far. And we've only got a few more weeks to go until we have our mid-semester break, and I'll keep you updated about that, obviously. And it'll be nice to have a little bit of a breather before we get into the second half of the unit as well. Just before I start today, I just wanted to also just note that as of probably when you're watching this, you will have your upcoming assessment one due reasonably soon. And so hopefully you've started having a bit of a think about how you might want to approach the critically engaged reading. I hope maybe you've chosen the article you want to focus on from the readings list of the unit, and just remember it's the first 4 weeks. So it'd be inclusive of this week and then not any further. I also just wanted to mention too, in terms of like how to approach the assignment, because I had a couple of questions along these lines, and I will mention this in tutorials as well. But it'll be in week three tutorials because I'm recording it before then. So I'll be making this point in week three tutorials. We want you to kind of approach the like conceiving and conceptualizing about the article through using that link to the Harvard Critical Reading resource, which kind of asks you about like what's the argument of the author, what are they contributing, what's the strengths and weaknesses of their position. We want you to kind of think about that, but the actual like mode of presentation or how you write the assignment itself may be quite different to that way of thinking about the paper. So you should probably instead structure how you write the assignment based more on the rubric. So you'll see in the rubric that it talks about the what like the argument that you're making using the literature and so forth. So what I kind of recommend to one of the students who talk to me about this is that you might approach this, read the article, try to critique the piece using that link to the Harvard resource, and then write a analysis of that piece, which goes into the topic and the principles and the areas of law that the piece you're focusing on engaged with, craft some kind of argument relating to that, which might maybe agree with the author, it might disagree with the author, it might present another point, and then kind of craft that argument in comparison with this piece from the author, as well as with the broader literature as well. So it should be kind of relating both to the piece you're critically engaging with, as well as the broader literature as well. And in doing so, you should be able to kind of articulate what are the legal principles that the author is engaging with, like the themes, the normative frameworks, and even the theories. And that should help you hopefully flesh out the assignment in a bit more detail. It's obviously, again, it's quite a short piece. It's only 1,200 words, but it's going to take a little bit of time. So don't leave it until right at the last minute, because it is a critically engaged reading. We want you guys to kind of engage deeply with it and also situate it in the broader literature. So there is an expectation you will read a little bit wider, at least than just the readings we have in the course. And using the textbook is permissible to an extent, but we don't want you to kind of like overly rely on the textbook for this assignment, or even any of your other assessment pieces as well. That should kind of be a foundation or a overview of these topics, which kind of gives you the foundational knowledge, which you can then build on through engaging in more, I guess, complex scholarly work. That's the idea anyway. But please keep sending me emails if you want to chat about assignment one. And like I mentioned in tutorials as well, I'm very available for consultation too, especially as we get a bit closer to the assignment. So just email me and we can schedule a consultation either in person or online, just depending where we are and when you'd maybe prefer a consultation. So, but that's maybe all I want to say about assignment one. And then once we, get through assignment one, we'll also then start talking about assignment two. So there won't be too much of a breather in between. And I'm also hoping to be able to give you all a little bit more of an update about the final assessment piece as well, but just give us maybe another week or two, and we'll hopefully have some more details about that final assessment as well. It's just in the works at this stage, and just because of the start of semester, it's just a little bit hectic at the moment. But I promise, we are finalising those details, and we are working on them actively. But anyway, enough about assessment. We don't want to maybe think about it too much, because we're going to go into a new topic for this week, which is really it's a really broad topic. And I've done my best to kind of touch on each of these points, and it obviously engages across a couple of chapters in your textbook, so it's very lengthy. And we're looking at jurisdiction as well as immunities and state responsibility. So these are all relatively big areas themselves, and I mean the plus state responsibility is probably a little bit facetious, because I mean, state responsibility is just not some small addition tacked on at the end. State responsibility is quite a large area of study, and it might actually occupy the most time of this particular lecture as well. And like I mentioned, as I usually am trying to do, I'm going through relatively similar areas that your textbook does, but I'm trying to have a lecture which is like an adjunct to it. So I, I kind of envision that it's good for you guys to engage with the textbook, then engage with this lecture, and I try to present some like associated adjunct, even some like deeper information at some points as well, and that hopefully combined together, you'll get a nice, well-rounded, like holistic overview of these topics. Is the aim anyway. And like I said, this is a very diverse and broad areas. So I'm just going to focus on what I think are the more key points. And in some of these topics, I'll be a lot more narrow than your textbook, and let the textbook kind of go through some of the important areas. And I'll highlight this as we go as well. I've also been trying to make a little bit of an effort to provide some more notes in these lectures as well. You can obviously print a transcript of what I'm saying here, but I also acknowledge that it's just probably a huge wall of text. So I generally try to keep the slides text free as much as possible, because I just think, like, I mean, the amount of content I'm kind of trying to get through, it just couldn't be presentable on slides, full stop. But if you have a look at the notes area of the PowerPoint that I upload, I am putting some key points there. I'm not going to provide verbatim what I'm saying. Obviously, you've got the transcript function that can do that. I'm just going to highlight some of the key points, which I think are either kind of important points to note, or even at least kind of like, central poles of the discussion, which you can then orientate the rest of the lecture around. So that's what I'm trying to do anyway. So hopefully I hope it is a little bit easier. But like I said, it is a lot of content. It's a lot of like principles and kind of theories and broader things than just your doctrinal legal subjects that like contract law or torts. Like, it's quite a bit different than that. So it makes the presentation a little bit more complex in some ways. So, like I mentioned, I lecture in contract law, that's much easier. I mean, it's just a dump of like the cases on the screen with the important points, as well as any associated legislation as it's relevant, like the ACL. So it's very doctrinal and quite much simpler to present than international law. But anyway, without further excuses myself, let's get into it, and we'll see how well we've done. So let me just progress the slides if I can work out how to do that. Here we go. So learning objectives today. Like I mentioned, it's a diverse area. We're going to be looking at jurisdiction, the certain immunities that we have as well, and then get into state responsibility. So the idea of jurisdiction is to kind of assign an actor the authority to speak on behalf of the law. This is the broad understanding or definition of jurisdiction. And the Latin origin of the term actually tells us that. And I'm going to butcher this, but the juris dicere, which means literally speaking law. Okay, so that illustrates that jurisdiction is about an actor with the authority to speak on behalf of the law. But when an individual is granted to speak from a position of authority, this also restricts others from doing so as well. And international law confirms this also contradictory, disempowering function of jurisdiction. So jurisdiction as a concept not only says like who can speak on an issue, who has the authority to speak on the issue, but it also, demarcates areas from one another. So it demarcates distinct realms. So it has, state jurisdiction is demarcated from other state jurisdiction. Domestic is separated from the international level. Another international sphere of competence is separated from another. So jurisdiction entitles states, as in our international law system, to exercise power within their territory by means of legislative, executive, and judicial authority. And international law kind of reflects the different natures of jurisdiction by distinguishing between jurisdiction to prescribe, so actually like make laws, enforce, which is making sure those laws are actually like observed, and also adjudicating as well. So this is the judicial reviews, adjudication, those kind of things. Um, and the development of jurisdiction in terms of its historical development kind of had a major progress in the 19th century, and this was marked by kind of increased formalization and increased formalities about whose territory was what, and this kind of had two main consequences. So, firstly, on the European continent, jurisdiction was exclusively tied to territory. And so territory was very important and one of the most important parts of jurisdiction. So who owned what? And then secondly, formal colonial governments and bureaucracies replaced chartered companies as the protagonists of colonial appropriation. And for those of you who might be familiar with the history, like the Dutch Empire, the English Empire, a lot of their initial kind of movement throughout the world and colonization was often pioneered by chartered companies. And in the 19th century, this started to fade away as colonial governments and bureaucracies replaced them. And this resulted in like a formalization of empire and also included the imposition of strict territorial boundaries in many of the colonies, and especially when different colonial empires were nearby. So, England would demarcate their colonial territory from France, who would demarcate it from Germany, for example. So just like I mentioned, international law uses jurisdiction for three key functions. It demarcates domestic jurisdictions from each other, like I mentioned. So it distinguishes domestic jurisdictions from one another. It distinguishes also domestic jurisdictions from international jurisdiction and separates other international jurisdictions from each other. In these demarcations, the concept of territory is central. In the kind of sense that territorial sovereignty is generally presented as the rule, and exercising jurisdiction without territory is seen as the exception. So generally, if any state power wants to exercise jurisdiction, it needs some kind of territory to do that, is the general rule. Now, the concept of territory itself is not innately tied to jurisdiction. The relationship between these concepts of territory and jurisdiction is actually contingent upon specific decisions made in the context of specific social, economic, and political constellations. And so territory itself is not just naturally there. Okay, we obviously associate territory with land, but they are also very different things. And so in that sense, it can be tempting to reduce territory to just geographical expanse, like the expanse of land, due to this physical underpinning of land itself. But really, if we look at it closer, territory is actually a social institution. It's shaped and constantly reshaped through cultural, social, and political practices. It is not just purely land. I won't go into too much detail, but there's a lot of really good critical literature that talks about, territory versus land and jurisdiction together, because these are all different categories that aren't watered down to any one, and they're not all the same as well. Um, Now, civil jurisdiction, there's different types of jurisdiction, like I mentioned before, and we'll focus on civil jurisdiction initially, and then we'll have a look at criminal jurisdiction as well. So jurisdiction entitles states to exercise power within their territory by means of, like I mentioned before, legislative, executive, and judicial authority. Like I mentioned in the tutorials, if you've done public law, or if you're going to do public law, this is a big focus of that area of study. And so jurisdiction is an important component then of state sovereignty. So we spoke about states last week, the ability to actually like make laws and enforce them within your own jurisdiction is a really crucial part of state sovereignty. And like I mentioned, this is why, again, at a civil domestic level, those types of jurisdiction are again important. So prescribing laws, enforcing laws, and adjudicating on those laws. Now, prescriptive jurisdiction, which is the creation of laws, allows states to stipulate rules that govern the relationship between humans, institutions, corporations, animals, objects, things, and even the broader environment. And then states can enforce those rules by relying on their enforcement jurisdiction. And then states may provide for some kind of judicial or quasi-judicial procedures for the observance, enforcement of these prescribed rules, or legal relations between subjects according to their adjudicative jurisdiction. So these three elements, work together. And international law does contain rules that deviate from this basic freedom of states to prescribe, enforce, and adjudicate, but it depends on the area of law and the subjects concerned, which will come up throughout our course, and we'll talk about those exceptions as they come up. Now, generally, states always have jurisdiction within their territory unless explicitly prohibited. And this view is primarily based on the famous or infamous, potentially how you see it, Lotus case. And this is a case I mentioned, I think, in week 2 in the lecture. And this is where the court at this time held that in the absence of some kind of prohibition, international law permits states to exercise jurisdiction. So states can even enact laws and render judgments that govern outside their territory. So in again that example of public law, when you study public law, if you haven't already, I often tell my students that many of the state parliaments in Australia can actually enact laws extraterritorially. Because their power is plenary due to the kind of historical basis of the states, and they've come from colonies and how they're federated. So they have plenary power. And so, like, for instance, Queensland Parliament could enact a law about littering in Indonesia if it wanted to. And it'd be a totally, arguably a valid law in some respects. But then the issue would be obviously enforcing that. So states can enact laws outside of their territory, but the general issue is how do you actually enforce it? And they can really only be enforced if there's permission to do so, and typically through treaties, or maybe in customary international law as well. So these three kind of principles of international law on jurisdiction about creating laws, enforcing it, adjudicating on laws. These also can be traced back to the three components of statehood. So these concepts of statehood and jurisdiction are really closely linked. And if you remember from last week, our components of statehood were territory, population, and government. So first, states can exercise jurisdiction if an act takes place on their territory. So that's, a linkage there. They can also exercise jurisdiction if their nationals act or are affected by an act on or outside their national territory. And that's relating to their population. And then third, states can exercise jurisdiction if the act at least affects the effective exercise of state power, so relates to the issue of government. Now, this third principle, which is generally accepted that yes, states can exercise jurisdiction if the act, which might be emanating from somewhere else, affects their effective exercise of state power. Um, it's generally accepted, but the specific definition and the circumstances when that can happen is highly contested. There's different ways of how states approach this, and probably most infamously, the very wide effects doctrine, which I think was mentioned in your textbook, which is generally most infamously again propounded by the United States. It basically means that any effect is sufficient. So any effect from anywhere in the world, which may have some kind of effect on the United States exercise of state power, then they can potentially have jurisdiction over it. So on the other side is the narrowest view. So that requires some kind of impairment of the internal or external security of the state for the state to actually then be able to do something. So compared to civil jurisdiction, which we'll note in a moment, states assume greater discretion for civil jurisdiction. And it's really up to the respective states to define their civil jurisdiction, which then results in differing practices. So, for example, in common law countries, jurisdiction is often based on this territorial principle. And so states then assert their jurisdiction over people as soon as people enter their territory, or a legal person, such as a company, registers themselves on its territory. So there needs to be that territorial link. Now, criminal jurisdiction, I'm not going to go into too much detail here. We do look at criminal international law as a whole topic a bit later on, and your textbook does a good job of going into the criminal jurisdiction here, which is more than sufficient. And all I'm going to do is just summarize the 5 grounds for jurisdiction. And your text goes into a lot more detail here, so I'm just kind of giving a few very brief summaries. So firstly, we have our 5 grounds here: territory, nationality, passive personality, protection principle, and universality. Passive personality and nationality are a little bit related, but starting with territory, states can exercise jurisdiction over crimes committed on their territory. Again, quite similar to civil jurisdiction in that sense. And this applies both to crimes initiated on a state's own territory but finalized on foreign territory, and to crimes initiated on foreign territory and finalized on a state's own territory. And I think, if I'm not mistaken, your textbook gives the example of someone in state A is shooting their gun across the river, which then goes across an international border and hits someone in state B. So then that would allow for criminal jurisdiction from state A or state B regarding that person. Now, based on nationality, states may exercise criminal jurisdiction if the offence is committed by one of their people of their nationality, and that's also called the active personality principle. Or likewise, states can exercise criminal jurisdiction if the offence is committed against one of their citizens, and this is called the passive personality principle. So, really, for our 5 grounds, we might actually call nationality active personality. So, if it's committed by one of their citizens, states can take action against them, and then the passive personality principle, where states can take action against or can exercise criminal jurisdiction if the offence is committed against one of their citizens. Now, the protection principle, and according to this principle, states may exercise jurisdiction over crimes committed on foreign territory by foreigners if the offence threatens the national security or some kind of like comparable interests of that state. And typically, and I mean, you even see this in Australia's practice as well, many states of the so-called global north in particular invoke this principle to penalise irregular migration. So in Australia's ongoing, still, I believe, and historical campaign against what it calls people smuggling, it would exercise jurisdiction sometimes in the seas of nearby countries, to be able to exercise jurisdiction over vessels, for example. Um, Now, finally, universality. And according to this universal principle, states can exercise criminal jurisdiction even though none of these other principles we've talked about, whether it's territory, active personality, passive personality, or the protection principle, even if none of them exist, if the crime affects the fundamental interests of the international community. So this is connected as well to Juice Kogan's crime. So it applies in particular and usually to piracy, slavery, genocide, crimes against humanity, war crimes, and torture. So these are the kind of five grounds for criminal jurisdiction. And this is all we're going to touch on jurisdiction here. Like I mentioned, your textbook goes into some of these points in more detail. And we're now going to kind of change track to diplomatic immunities, which does obviously have some relation to jurisdiction in itself, but is, I guess, a slightly different topic. And the concept of, and I mean, diplomatic immunity is the main thing that we're kind of looking at here is like, who can claim immunities from state jurisdiction. So it's kind of related in that sense. And so we're going to be talking about, diplomatic missions, consular relations. We'll have a look at the Vienna Convention as well. And then what aspects of, diplomatic and consular missions have this inviolability protection. Um, and starting out thinking about, well, what are diplomatic relations? This refers broadly, in a way, how states interact with other subjects of international law, which might be states themselves, it might be other international organizations. Different levels of diplomatic missions also serve to achieve different goals. So, for example, we have embassies, which are the official representation of one state in the territory of another, which usually offers political representation, but also services for citizens abroad. Um, and between associations of states, such as the Commonwealth, a permanent representation of a member state in the territory of another member state is fulfilled under a high commission. Whereas a permanent mission, on the other hand, is usually what we call a permanent representation of a state before the governing body of an international organization. And so these diplomatic relations and these different forms of diplomatic relations, these give way to consular relations, but they're not quite exactly the same thing. Mm. Uh, Consular relations indeed can exist without diplomatic relations. Consular relations are technical and administrative relations which are aimed to procure the rights of citizens abroad. They're regulated by what we call a mixed regime of not only public international law, but also domestic law. And consular relations, similar to diplomatic relations, are born from a mutual agreement between the recipient state and the sending state. At the international level, two conventions are particularly relevant here. So the Vienna Convention on Diplomatic Relations, which we'll touch on in a bit more detail as well, and the Vienna Convention for Consular Relations, which doesn't really have a big focus for us because the consular level is more technical and administrative. So we usually focus a lot more on the Vienna Convention of Diplomatic Relations. And this convention, and I'll refer to it in shorthand as the Vienna Convention. This is the Vienna Convention on Diplomatic Relations. It was written and passed in 1961, and it's the main instrument that regulates diplomatic law. This Vienna Convention, which reflects and develops customary law, includes the functions of diplomatic missions, their rights, their privileges, and their obligations of both the sending and the hosting states. And I mean, it's important also just to note too that diplomatic relations have a history way back in time. And pointing to where the diplomatic relations start is always problematic. And again, Has been a very long history of diplomatic relations, but the conventional way in international law, which we might not necessarily agree with, is usually to start again with Westphalia or marking it as a major milestone in the development of diplomatic relations between the entities of international law, which would become states. Um, at this time, as sovereignty was being discussed and a major aspect of how states related to each other on the international scene, delegations from all countries started to gain protection against civil jurisdiction around that time, Westphalia, and developing from it. And so, since that moment, it became quite a standard practice, and also later developed in customary international law. To have diplomatic relations. And even our friend Hugo Grotius, who we mentioned in week one, also wrote a bit on diplomatic relations and immunities. Now, the key kind of aspect that I'll touch on here about diplomatic and consular relations is about the inviolabilities that are relevant. I'm not going to speak so much directly on the immunities, which your textbook does really well, but just kind of go a little bit more into the inviolabilities of these diplomatic and consular relations. Um, and this is like kind of a key aspect as well of immunities too. And this was kind of first, I think I also first mentioned this in week one or probably week one, maybe week two, that foreign state officials have um, uh, immunities in other countries. And the importantly for our conversation at the moment, the Vienna Convention on Diplomatic Relations establishes the inviolability of the diplomatic mission, which is said to kind of represent the foreign state in a different state's territory. And this is in Article 22. And such obligations here implies that inspections, registers, or other types of intrusions are strictly prohibited. Against diplomatic missions. And so this not only obliges the hosting state to abstain from interrupting into the diplomatic mission, but also to guarantee the safety and well-being of the mission itself. And this includes the duty to prevent public demonstrations in the vicinity of the mission that may escalate to endanger the security of the diplomatic seat. And a historical example of this particular situation is the 1984 storming of the Libyan embassy in the United Kingdom. And armed subjects from within the Libyan embassy fired against civilians on the street, and then it was stormed there. So that was an example of that happening. And without a waiver by the sending state, diplomats are also personally inviolable and absolutely immune from any form of arrest or detention or other exercise of criminal jurisdiction for the duration of their posts. They also enjoy immunity in relation to most civil and administrative proceedings, apart from three types of proceedings. So real actions involving immovable property, actions relating to succession, and also suits relating to commercial or professional activities undertaken outside of official functions. Whereas by comparison, consular officials may be arrested or detained pending trial in the case of a grave crime and pursuant to the decision of a competent judicial authority. And consular officials also possess immunity for acts performed in the exercise of their consular function. That's Article 43 of the Convention. And these provisions kind of reflect a more functional approach to immunity for consular as opposed to diplomatic agents, as well as a balance in favor of the interests of the receiving state in ensuring compliance with local laws by these consular officials. Now, as with the issue around the immunity of the foreign sovereign, which we'll actually talk about quite soon, there is a scope of or this scope of commercial activities exception to diplomatic immunity, and it's created a lot of debate in the literature. And this issue has arisen predominantly in relation to claims by persons employed as domestic workers by diplomatic missions. So you have diplomatic missions and they employ workers domestically. And there's been some cases around those workers attempting to sue the uh, diplomatic officers or diplomatic persons in relation to those engagements. So, for example, in 2022, the UK Supreme Court in Basfar vs Wong concluded that a serving diplomat was not entitled to immunity from civil jurisdiction in relation to a suit brought by a migrant domestic worker who was employed in the diplomat's residence under conditions amounting to modern slavery. And in explaining its reasoning for this case, the court observed that while this commercial activities exception did not encompass ordinary contracts, which are incidental to daily life in the receiving state for the diplomats and their staff, the abusive working conditions complained of were not incidental to the ordinary functioning of the diplomatic post. Um, but in contrast to this particular outcome, US courts, for example, have disagreed over whether the commercial activities exception applies in similar circumstances, with most holding that abusive employment only falls outside the scope of a diplomat or consular official's residual immunity. Now, on this kind of track, let's talk a little bit about foreign state immunity, which obviously the immunities of the diplomats kind of radiate from this foreign state immunity, and these immunities derive from a combination of principles in international law, including the sovereign equality of states and non-interference, which is what we mentioned last week. And immunity is ultimately owned to the foreign state, and on that basis to certain classes of persons and entities embodying or representing the state or carrying out state functions. And again, this idea historically of foreign sovereign immunity emerged from the notion that no sovereign or its courts could sit in judgment of another sovereign. So while foreign sovereign immunity developed strong roots in domestic legal systems, it also came to be recognized as a rule of customary international law. And today, sovereign immunity is also described as drawing roots in these principles of sovereign equality of states, of non-intervention, and the peaceful settlements of disputes. And this is, reflected in the UN Charter and other contemporaneous sources. And at the domestic level, there has also been a few states that have adopted legislation that codify rules on foreign sovereign immunity. In the US and UK, they have foreign sovereign immunity acts as well, in addition to what your textbook notes too, which sets out immunities owed to foreign states and their agencies or instrumentalities in the absence of a applicable exception. There's also other states like Sweden, Egypt, and South Korea, which give effect to sovereign immunity by applying customary international law directly. Now, the ICJ's opinion in the jurisdictional immunity case, which I'll also touch on a little bit later too, provides an example of how, in practice, a variety of different sources may factor into a determination of the customary rules of state immunity. And so this was a case between Germany and Italy, and the court was determining whether Italy's courts were prohibited from entertaining actions against Germany for severe violations of human rights carried out in World War II. And the court looked to judgments of national courts, the legislation of states which have enacted statutes dealing with immunity, as well as to claims to immunity advanced by states before foreign courts and the statements made by states during the drafting of like UN conventions and other sources to determine, how can we in practice factor in this idea of jurisdictional immunity. So the court looked at a whole different lot of sources to kind of arrive at their particular decision in this case, which I'll touch on a little bit later. So in practice, I think this ICJ case of jurisdictional immunities demonstrates that it's not just a customary law, it's not just the domestic legislation that's important for our jurisdictional or immunities of the foreign state, but it takes into account a whole range of sources, which also relates back to our earlier discussion about sources. Now, the most important development over the last century relating to foreign sovereign immunity is the evolution away from a more absolutist or absolute doctrine of foreign sovereign immunity towards a more restrictive one. And under the more modern restrictive approach, immunity is limited only to public acts and does not apply to private or commercial acts. And this approach typically applies to both immunity from actions, like from suits, or immunity from execution. Now, several different factors are said to have driven this evolution away from an absolute approach, which is that there is no way where foreign states and their representatives wouldn't have immunity, and a lot of this is around the expanding commercial activities of states in the 20th century, and also the perception that absolute immunity enabled an unfair commercial advantages for state-owned industries and entities that competed internationally. So while most states today now adhere to a more restrictive approach rather than an absolute approach, some states, and probably most famously the Soviet Union, were historically more reluctant to adopt it, which is probably because the Soviet Union obviously had more state-owned industries and were more keen on the absolute immunity approach. Um, Now, the issue with this is that determining the nature of state acts as either sovereign in one category or commercial in another is critical when implementing the restrictive approach, which can be quite problematic. Now, as set out in the various UN conventions, the state includes all organs as well as constituent units, agencies, and representatives who exercise some kind of sovereign authority. And so the activities of these persons or entities will generally constitute sovereign acts for purposes of immunity. But more kind of difficult, I guess, or a more difficult declaration under the restrictive approach is to determine whether a state is immune in relation to certain contracts or transactions, so certain commercial processes or acts. And when we assess whether certain acts, which may, in one sense, perhaps be sovereign acts, whether they constitute commercial acts, courts primarily look at the nature of those acts as opposed to the state's purpose in carrying them out. Though there are lots of competing rulings and different jurisdictions kind of have different approaches to this issue. But for example, under the more modern restrictive approach, the state may not be immune in relation to a commercial contract to buy military equipment, even where the state's ultimate purpose is to outfit its military, which is obviously a very traditional sovereign function. And so if we focus on the nature of the transaction, it has the effect of lifting immunity in that particular example. Now, when we think of, well, who is or what is entitled to this immunity, international law also extends immunity not just to the actual representative of the sovereign, whether it's like a president or a king, queen, whoever it may be. International law also extends immunity to foreign state officials in certain circumstances. While in some jurisdictions, foreign sovereign immunity may apply in civil suits where a head of state is sued in his or her public capacity, and thus is a stand-in for the foreign state, different international rules apply to heads of state and other high-ranking officials when sued personally. And the rationales or the reasons offered for foreign state official immunity also overlap with those for foreign sovereign immunity, such as those ideas of sovereign equality of states, non-interference, and so forth. But foreign official immunity has the added rationale of facilitating orderly international relations, particularly as some high-ranking state officials are routinely required to travel to participate in diplomatic meetings. Now, there's two types of immunities owed to foreign state officials under customary international law. The first one is ratione personae, or status-based immunity, and this is owed only to very high-ranking officials, such as the head of state, the Minister of Foreign Affairs, and the head of government. And these three are referred to as the Troika. Okay, so it's important to note these are the Troika, and they have a status-based immunity, or ratione personae, and they're considered inviolable for the duration of their office, so they enjoy full immunity from the exercise of foreign civil and criminal jurisdiction, including both official and private acts. And in the words of the ICJ, immunity and inviolability protect the individual concerned against any act of authority of another state which would hinder him or her in the performance of his or her duties. Now, the second type of immunity, this is called ratione materiae, or functional immunity. This attaches to acts which are carried out on behalf of the foreign sovereign. So unlike ratione personae immunity, which expires at the end of the official's term in office, so once they're not an official, they don't, enjoy that immunity anymore. Ratione materiae immunity can be raised even after an official leaves office, as this form of immunity attaches to conduct which can be considered sovereign. So in contrast to ratione personae immunity as well, whose application to high-ranking officials beyond the Troika remains quite uncertain, ratione materiae immunity can in principle attach to a much broader range of actors, given that the immunity is based on the nature of particular acts rather than on who the officials are. And in terms of the practicalities of this, foreign official immunities apply regardless of whether the official is traveling as part of their duties, and so it's not contingent on a receiving state's grant of credentials for the official to enter the state. The home state of the official may also waive these immunities because they're ultimately owed to the state and not granted for personal benefit as well. Now let's talk about the immunity for Jus Cogens violations, and we'll think about this from the immunity from the state perspective as well as from officials, and we'll touch on a few important cases that deal with these questions. So, like we mentioned, this idea of foreign sovereign immunity is established as a matter of customary international law. The kind of exceptions of it remain really subject to debate, and probably the most important debate is that whether foreign sovereign immunity applies in relations to violations of Jus Cogens, or whether a limit to or exception to this immunity exists in these cases. So in that jurisdictional immunities case, which I mentioned before, between Germany and Italy, the ICJ actually rejected Italy's argument in favor of a customary exception to immunity for claims relating to Jus Cogens violations, which included large-scale killing of civilians, and deportation of civilians to slave labor. And the court reasoned that there was no conflict between the application of immunity and underlying Jus Cogens rules because the two sets of rules address different matters. And in reaching this conclusion, which I think logically is a bit hard to follow at some points, and we don't have to know this case in any huge detail, but the court held that on one hand, foreign sovereign immunity was basically procedural in nature, procedural kind of technical rules, and in contrast to human rights and humanitarian law rules, which are more substantive, and that they could exist both together. And they don't necessarily have to overlap, or the more procedural notions of immunity are knocked out by Jus Cogens violations. And then the ICJ also further rejected Italy's argument that customary international law recognizes a territorial tort exception for claims in relation to violations carried out in the foreign state. Now, this approach to this relationship between Jus Cogens and immunity followed also a similar decision in Al Adsani versus United Kingdom, which is a European Court of Human Rights case, where they found there was no violation of the right to access to the court in relation to the application of immunity to a complaint alleging violations of torture. So overall, for the state, the just it seems like on the face of it that not there's not always a recognized exception for immunity to be waived away by Just Kogan's violations. Now, similarly with this foreign sovereign immunity, there's also important debates around the question of whether foreign official immunity is available in cases involving alleged Just Kogan's violations. And this question has taken on increased importance as mechanisms, especially since the early 2000s, concerning international criminal accountability have solidified and have as many states have ratified various human rights treaties that requires the prosecution of certain violations by individuals. Now, in the arrest warrants case, which is the Democratic Republic of the Congo versus Belgium, the ICJ rejected the possibility of an exception to rationale personae immunity on the basis of alleged violations. And they found that Belgium's issuance of a warrant for the arrest of an incumbent foreign minister from DRC violated their immunity, despite allegations that they had committed crimes against humanity. And so states have largely accepted this relatively absolute approach to the troika of the rationale personae immunity. The perspectives around this issue are more varied as it relates to rationale materiae immunity, and whether that can apply to Just Kogan's violations. And probably one of the most famous cases in this for this question is that of Pinochet number 3. So in the UK, this case serves as a prominent example which denied rationale materiae immunity in relation to prior acts of torture. I'm not sure how much of the history you guys know about this, but in the early 1970s, I believe, Augusto Pinochet overthrew the democratically, who was a general, he overthrew the democratically elected government of Chile, led by Salvador Allende, with the help of the United States. And after Pinochet took over, instituted a military dictatorship, which was accused of disappearing thousands upon thousands of people, conducting widespread torture against the population, and other forms of terror. And in I can't remember the exact year, but sometime after these events, I think maybe in the early 2000s. Augusto Pinochet, the former dictator of Chile and was the former president, went to England to get some medical treatment for his condition that he had, and Spain made a request to arrest him. And in this case, which was around those issues, the Pinochet number 3, the House of Lords here in England upheld this request made by Spain to arrest Augusto Pinochet on the basis that he was not entitled to immunity in relation to the acts of torture that he had committed or at least overseen and authorized as president of Chile. But all of their honors were divided as to their reasoning, which made it a little bit more complex for some kind of rule to extend from that case. The majority held, though, if we can kind of connect the threads together, that the UN Convention on Torture established an international crime rendering immunity in relation to these acts inapplicable. So some lords in Pinochet number 3 took the perspective that an exception to immunity applied for torture, while others held that torture is not an official function of the head of state. So debate over these issues, still certainly continues today, and they've also increased following the International Law Commission's adoption of a draft article which recognized an exception for certain international crimes from immunity, such as genocide, crimes against humanity, and torture, as a part of its kind of broader work on this topic of foreign official immunity. But state practice in support of this exception appears to be quite limited, and only a handful of states have really provided a clear international crimes exception to immunity for ratione materiae. But then there's also been a few domestic courts that have denied immunity on this basis. Excuse me, including Germany in 2021. But it is an evolving area of law, and it's probably an active question today as well. Excuse me. So now we've kind of spoken about jurisdiction. We've gone through a bit of the diplomatic relations and immunities and inviolabilities of consular and diplomatic relations. We're now going to kind of quite drastically change tack, I guess, to state responsibility. Um, Again, this is maybe slightly disconnected in a sense from these previous two topics, outside of the sense that jurisdiction is usually an important question of state responsibility, which we'll touch on, and diplomatic relations also has some kind of relevance here, especially in terms of the impacts and implications. Now, starting in 1956, the International Law Commission started to focus efforts on thinking and developing a series of articles on state responsibility. Again, after the horrors of World War II, it was thought it was important for there to be some kind of international law around state responsibility. And in the early 2000s, they had approved the draft articles on state responsibility for international wrongful acts, or ARSIWA, and this text was submitted to the UN General Assembly. There was the intention of actually changing this draft to a treaty, but this never actually materialized. And even though it is called draft articles, a lot of the ARSIWA does reflect international customary law, and so the articles are widely applied in practice. So it's important for us to know about it. And just to point out a couple of, or maybe just one important article at this stage, and I will touch on some others, but the first article to start with is that of Article 1, where it establishes the principle of state responsibility. It says, and I quote, "Every internationally wrongful act of a state entails the international responsibility of that state." So this direct relationship between a wrongful act and responsibility has been classified as a form of objective responsibility, because it's not dependent on elements such as negligence, guilt, or some kind of subjective responsibility like intention and those kind of things. It's objectively, if there's a wrongful act by a state, then that entails responsibility. And this idea of state responsibility is the set of legal relationships and obligations that emerge between subjects of international law once an internationally wrongful act is attributed to a state. The content of these potential new obligations consists of the consequences of the wrongful act and varies from case to case. So let's talk about the elements of state responsibility. And we can really kind of just break it down to two main ones, or at least a two-tiered consideration of the elements of a state responsibility. The first step is to actually establish that there's some kind of internationally wrongful act. And the second step is to basically then ask or review, well, is this conduct by the state justified? And an internationally wrongful act is defined in Article 2 of what I'll just call the Act for shorthand. This is the ARSIWA, and it says it's conduct that consists of an act or omission that's attributable to a state and constitutes a breach of binding international obligations of a state at that time. And so this means we have to identify conduct which consists of an action, like a positive act against a primary obligation, or an omission, so failure to take some kind of measure, some kind of inaction that breaches a primary obligation. Second, that it's attributable to the state, And so we have to look at criteria, which I'll touch on a bit more soon, about whether individual groups can be linked to a state as agents or subjects under their control. And three, it's a breach of an international obligation of that state. So this emanates from a rule which can be represented in any source of international law, which might be treaties, customary law, including Jus Cogens obligations as well. And it's important to note as well that some kind of harm or damage is not actually a constitutive element of the notion of an internationally wrong act. A breach of a treaty can occur without actual harm. So, for example, an unauthorized movement of troops from one state to another, the troops might just like come in to a state's territory and then leave again. It might not actually harm the territory of the state. Might not be any damage per se, but it doesn't matter if there's still an obligation breached there. Now, one of the most vexing questions of these kind of three points in terms of like conduct, is it attributable? Is it a breach of international law? Is attribution of state responsibility? This is kind of usually the most vexing kind of issue. And this is a legal exercise that we have to do when we're trying to attribute conduct to a state, where the conduct of an organ, a person, a group of persons, or whoever may be, is imputed on that state in accordance with criteria determined by international law. And so then the state will be considered the author of that act. The legal consequences will fall on it. Without also prejudice to potential legal consequences that may fall on the actual material author of the act, for example. So individuals might face some consequences from international criminal law, but if the state can also be demonstrated to have that conduct attributed to them, then the state will be also considered an author of that act. But it's important to note that in principle, the state is responsible only for wrongful acts of its organs and agents. So private persons are not attributable to the state under international law, generally speaking. And also not every conduct of organs and agents of the state is imputable to the state. Okay, so just because there's an organ or an agent of the state doing something, it doesn't mean it's always going to be attributable to the state. We still have to like go through the process and think and conceive and determine that relationship. Now, importantly here, as I've noted on the slides, Article 4 of the Act provides that the conduct of any state organ, whatever its position or function within the state, is considered an act of that state. So that is basically saying the responsibility extends to any state entity, whether it exercises executive, judicial, legislative, or even commercial functions at different levels. And the domestic law of the state also plays a fundamental role in establishing whether a given entity constitutes a state organ for the purpose of international responsibility. But the conduct of institutions exercising public functions is attributable to the state, even if under domestic law, such institutions are considered independent or autonomous. And so according to Article 5, the conduct of any person or entity empowered by the domestic law of a state to exercise public functions is attributable to the state if the person or entity acts in that capacity. So this is like a functional criteria. So it refers to the function exercised by the individual or entity, regardless of whether it's structurally considered to be a part of the state or not. So the state can be liable for the wrongful conduct under Article 5 of like parastatal entities or public, semi-public, or even private companies if one, they are empowered by domestic law to like exercise certain public or regulatory functions, and two, the act is related to the exercise of the assigned public or regulatory function. Now, one of the other important issues here is around control. So Article 8 provides for a criterion where the conduct of a person or group of persons acting on the instructions or under the direction or control of the state is a de facto state organ. And their behavior is considered attributable to the state, even though from an administrative or a structural point of view, they're not an organ within the official structure of the state. So one of the I mean, most common examples, or one of the common points this comes up, is in an armed conflict. The internationally wrongful act of a paramilitary group fighting against government armed forces may give rise to the international responsibility of the third state if that paramilitary group is fighting under its control. Um, Now, there's several criteria regarding this threshold of control that's needed to attribute conduct of private entities to a state, and this has emerged from the practice of international courts. So the ICJ has developed a very strict notion of effective control. And this was most famously probably seen in the Nicaragua case, the military and paramilitary activities in and against Nicaragua, where the case was basically one of the main questions was, did the United States have effective control over the right-wing Contra rebels who were waging a guerrilla war campaign against the government. And so the ICJ developed a very strict notion of effective control. And also the International Criminal Tribunal to the former Yugoslavia also developed an overall criterion that didn't require direct effective knowledge or control of every act committed by an entity and the direction of its goals. So there are some kind of differences in how courts have considered this issue of control, which is worth being aware of. Now, in certain situations, the breach of an obligation. So, if we've said like, yes, there's a breach of some kind of obligation, we then need to start thinking about, well, are there circumstances where it may be excused? And maybe the consequences of the breach could be avoided. And we call these circumstances precluding wrongfulness. They kind of apply to obligations arising from any source of international law. So these are the general kind of categories that we'll look at to see if this breach may be excused. So the first one is that of consent. And so Article 20 of the draft articles provides that a state may obtain the consent of another state, which, if they didn't have this kind of permission, would constitute a wrongful act. So to be valid, a state this consent must be given by state authorities who are registered to represent a state and bind it internationally. So if one country moves their army across the territory of a state, which would be internationally wrongful act, generally speaking, that state may consent to that, perhaps for their security, they're looking for that state to help them, or they're allowing the passage of their army through their state to regions unknown or further regions. But this consent is not required to be given through an instrument as such as a treaty or, for example, some kind of like formal written document. And it can extend before and during the occurrence of the allegedly wrongful conduct. But the limits of this consent must be respected, or there will be wrongful acts established. Like a different example, in a case of a country giving permission to another country to cross its airspace to maybe attend to some kind of specific situation, if like that consent was given and it was just for that, passage of an airplane from one state over another, and then that state kept sending, over flights when that consent hadn't dealt with those subsequent flights, then each subsequently would be a wrongful act. Now, the second potential circumstance precluding wrongfulness is that of self-defense. So wrongfulness can be excluded if a state breaches its international obligations in the act of self-defense under Article 2, subsection 4 of the UN Charter, whether against the state from which it is repelling an attack or against third states. And this is Article 21 of the draft articles. Self-defense as a circumstance precluding wrongfulness, though, has certain limits. On the one hand, for the circumstances to be valid, the state invoking it must comply with all of the substantive and procedural elements described in the UN Charter on self-defense and the general prohibition on the use of force. And we will talk about this a little bit later on in a different week. And likewise, acts carried out in the context of self-defense must respect international humanitarian law. Now, finally, the other kind of third main category, which we look at for circumstances precluding wrongfulness, are countermeasures. And these are reactive actions against a state's wrongful conduct, which seek to compel it to return to compliance with a breached obligation. These are kind of measures that seek to have a sufficient effect on another state that's breached an obligation so that it ceases its non-compliance. And so these can be like legal reprisals or sanctions in some proceedings. In these kind of measures, it may actually breach obligations between two states. For example, this might be the enactment of a tax bill, which might be prohibited by free trade agreement to induce another state to return to compliance with its obligations, or sanctions, as well would be an obvious example too. And countermeasures are a circumstance which excluding wrongfulness if they meet certain requirements. So they need to be proportionate, temporary, and be lifted once the breach has ceased. They also may not constitute measures of armed force and must be reversible in nature and not punitive in character as well. Now, in terms of consequences for an internationally wrongful act, we don't need to know these in huge amounts of detail, but I'll just note a few important points, is that Article 28 of the draft article says that there is a general principle that an internationally wrongful act produces legal consequences. So the responsible state will be subject to several obligations, which also doesn't discount other consequences which may be provided under different regimes as well. The Article 30 of the draft articles provides obligations of the responsible state. So it says that the state must cease its wrongful conduct, for example, and the state may be obliged to also provide assurances and guarantees of non-repetition of its wrongful conduct when it's deemed necessary for restoring confidence between the parties and preventing future violations, for example. There's also reparations. So Articles 31 and 34 state the obligation to make full reparation for damages caused by a wrongful act, including material, moral damages, as well as interest as well. The forms of reparation may be given, in a single or combined form. And there's also some kind of specific treaties and jurisdictions under like regional human rights systems that may require the forms of reparation be given in the face of serious human rights violations to achieve this idea of like bringing the parties back to the position they were initially, as much as possible anyway. But the first measure of reparations, and this is in Article 25 of the draft articles, is restitution. And this is trying as best as possible to return the situation as it was before the International Wrongful Act. And this takes the form of material conduct, such as the release of persons who might be illegally detained, the return of property, reversal of judicial decisions, or a legal norm that violates an international obligation, withdrawing of troops, and so forth. And I mean, this idea of restitution is obviously only available as a path within reparations in cases where it's actually materially possible to return to previous circumstances. If a whole area is totally erased, then that's going to be difficult. If restitution is not possible, in those kind of circumstances. Article 36 does provide compensation as another way of redressing an injury caused by an internationally wrongful act. Compensation corresponds to the payment of any damage that's susceptible of some kind of financial assessment, and this also includes loss of profits if it can be proven. For example, and there is international jurisprudence that's repeatedly held that a court that has jurisdiction to declare the international responsibility for wrongful act has jurisdiction to also produce a judgment fixing the amount of compensation, unless it's otherwise agreed by the parties themselves. The practice of tribunals has not only recognized compensation for damages caused to the property of the state, but also for environmental damage, even violations of investment structures, loss of profits, and injuries to individuals as well. Now, finally, no, I don't have another slide for that. But also, as a final point, I just wanted to make are the consequences for a breach of a jus cogens norm. Um, so if there is a flagrant or systemic violation of a peremptory norm, our jus cogens norms, like in the case of genocide or torture, this also gives additional obligations for the international community as a whole. And Article 41 of the draft articles provides for the obligation of all states to, one, cooperate to put an end to the violation, either within the framework of the UN or through any other lawful measure. Two, not to recognize as lawful situations resulting from this violation. And three, not to give aid or assistance to the responsible state to maintain the situation of non-compliance. So that's consequences for the breach of a jus cogens norm under Article 41. Now, as you probably saw, as I was filtering through my slides, that is now the end. So we have tutorials coming up this week as per usual. Please ask me any questions that you have, especially about your assignment as it's coming closer to the due date. Try your best to do the required readings and especially the textbook if you can. And thank you very much again for paying attention to the lecture and engaging with it. I look forward to seeing you all in class very soon. Thank you very much, everyone, and I'll see you soon.